Right now, if the forecast in Washington, D.C. drops below 32 degrees tonight, federal marshals are not allowed to evict anyone. Not a formality, not a rumor. An actual policy that pauses evictions the moment it gets that cold. Most tenants have never heard of it. And it's just one of several real, very specific winter protections that people either don't know exist or wildly overestimate. There's no nationwide law that stops evictions in winter. But there are real ones, in real places, with real trigger conditions. And knowing exactly how they work can be the difference between losing your home and buying yourself weeks. By the end of this video, you'll know exactly which protections might apply to you and what to do if none of them do. Number 1. 2 different kinds of winter protection, and they work nothing alike. There are 2 completely different systems out there: date-based bans and temperature-triggered halts. Date-based bans work like a calendar. In Seattle, there's a winter eviction pause running December 1st through the end of February, and a separate school year pause running September through June that protects low and moderate income households, plus anyone connected to a school as a student or an employee. Both come from actual city law, Seattle Municipal Code 14.09.026. In Pennsylvania, the standard moratorium runs December 1st through March 31st, but only for households at or below 250% of the federal poverty level. It's not universal. It's tied to income. Temperature-triggered halts work completely differently. They're not about the date on the calendar. They're about the forecast. In Washington, D.C., if the forecast drops below 32 degrees, the U.S. Marshals, who carry out evictions there, will not execute one for the next 24 hours. In Cook County, Illinois, which includes Chicago, there's a holiday ban from December 19th through January 5th that covers everyone, and separately, a temperature halt below 15 degrees specifically to protect vulnerable populations. Both are enforced through the sheriff's office as a matter of policy. Here's why the distinction matters. A date-based ban protects you no matter what the weather does that day. A temperature-triggered halt can end the moment the forecast warms up, even in the middle of January. If you're relying on one of these, know exactly which kind it is. Number 2. Even without an eviction ban, your heat can be separately protected. This is the part almost nobody connects. An eviction protection and a utility protection are 2 completely different legal categories, and you can have one without the other. In New Jersey, landlords are required by law to maintain at least 68 degrees during the day, from 6 a.m. to 11 p.m., and 65 degrees at night, every day from October 1st through May 15th. That's not a shutoff ban. That's an active legal temperature standard your landlord has to meet, regardless of what's happening with your lease or your rent. Pennsylvania also runs a separate winter utility moratorium from December 1st through March 31st. And in a recent example of how fast these protections can shift, Pennsylvania secured a special one-time bridge commitment in November 2025, specifically to keep LIHEAP-eligible households protected from shutoffs during a gap in federal heating assistance funding. That protection was temporary and tied to that specific funding gap, which is exactly why you have to check what's actually active where you live right now, not what a video told you months ago. Number 3. The repayment plan defense most tenants have never used. In Washington state, there's a legal concept worth understanding even outside its original context. Under RCW 59.18.630, landlords were barred from taking adverse action, including eviction, over rent that built up between February 29, 2020 and May 1, 2023, unless they first offered the tenant a reasonable repayment plan. A reasonable plan had specific requirements. The monthly installment couldn't exceed 1/3 of the monthly rent, and the first payment couldn't be due less than 30 days after the plan was offered. Here's the part that matters in a courtroom. If the landlord never offered a plan meeting those terms, that failure is itself a legal defense to the eviction. Not a technicality, an actual defense a judge has to weigh. If you still have unresolved back rent from that window, raise this with a tenant attorney immediately. And one more myth to clear up while we're here. Washington used to also require landlords to go through a mediation program before filing. The Eviction Resolution Pilot Program. That requirement expired on July 1st, 2023. It's no longer part of the process. If someone tells you mediation is mandatory in Washington, that information is out of date. Number 4. No protection changes how the eviction actually has to happen. Even in a place with zero winter-specific rules, this never changes. A landlord cannot legally remove you without going through court in any season. The formal process is called an unlawful detainer action. The landlord has to file a case, properly serve you with notice, and get in front of a judge. If the judge rules against you, the court issues a writ of possession, a legal order. And only then does a sheriff or marshal carry out the actual removal. That's the entire legal chain. There is no shortcut. Anything outside that chain is illegal everywhere, regardless of the weather. A landlord shutting off your water, changing your locks, or removing your belongings without a court order isn't an eviction. It's called constructive eviction, and it's against the law in every state. If it happens to you, call the police immediately. You have the right to remain in that home until a court says otherwise. Number 5. What to actually do if you're facing this right now. First, find out exactly which category you might fall into. A date-based ban tied to income or school enrollment, a temperature-triggered halt, or a separate utility protection. These are not the same thing, and you may qualify for more than one. Second, if you have older pandemic-era rent debt, ask specifically whether your landlord ever offered you a compliant repayment plan. If they didn't, that may be a live defense. Third, document your heat. If your unit is below the legal minimum temperature for your state, write down the dates and the readings. Fourth, contact a local tenant hotline or legal aid office immediately. Many jurisdictions still offer free mediation through local dispute resolution centers, even where it's no longer mandatory. Fifth, show up to every court date. The unlawful detainer process only works in the landlord's favor if you're not there to respond. So, let's recap. There's no single nationwide winter eviction ban, but real ones exist, and they come in two forms: date-based calendar bans like Seattle and Pennsylvania, and temperature-triggered halts like DC and Cook County. Separately, your heat may be legally protected even without any eviction ban at all, especially in states like New Jersey and Pennsylvania. If you have unresolved pandemic-era rent debt, a missing repayment plan could be a real legal defense. And no matter what protections do or don't apply to you, the eviction still has to go through a judge and a sheriff, never a landlord acting alone. This video is for educational purposes only and is not legal advice. Laws vary by state, county, and city. Always verify current statutes for your specific jurisdiction before relying on any figure or deadline. Consult a licensed attorney for advice on your specific situation. Have you ever dealt with a landlord who tried to cut corners on this process? Let me know in the comments below. Your situation might be exactly what the next video needs to cover. If this helped you, hit subscribe. Every week we break down real legal situations in plain English, using the actual laws behind them. See you next week.